Susanna Fielder. She's been working with PI for many years, and one of her roles has been chair of PI, and she's continued to help PI with policy advice around data protection.
And this is Ailidh, and she is PI's lawyer extraordinaire and a huge expert on general data protection regulation. And together we will talk to you about GDPR, as it's well known by now, what it has achieved, what it is about, and why it is important. And a lot of you would have heard recently, even if not before, about GDPR. Most likely your email inboxes are invaded by many, many messages asking you to opt in to continued spam, or you can take the opportunity to opt out. And the same is happening all around Europe. More seriously, you would have all heard recently about the scandal of Cambridge Analytica collecting illegally a lot of personal data from Facebook account via an app, and the impact that would have had on democracy and election. So clearly data protection is something very important. It is a tool to exercise your human right to privacy. It's also a very good safeguard against industries and government insatiable greed of collecting more and more personal data for various purposes. Another important thing to say is that this is not a new legislation. It's an evolution of existing law that exists in Europe, but they were inadequate and inefficient because they came into being in Europe in 1995, and since then we've had the internet, we've had big data, we've had profiling and targeting, so this law have become inadequate and no longer fit for purpose and couldn't be enforced properly. So we've embarked on a huge revision that started in 2012.
Yeah, so you were working for PI on GDPR at that time. So if you could explain a bit about PI's role in GDPR?
So I've been working for PI for over 10 years now, and at that time Privacy International was a very small but very efficient organization. It has grown and it's become big and even more efficient since. So I was representing Privacy International in Europe, where this law was being developed. And I had to work very closely with a team of sister organizations because the lobbying by industry and even foreign governments was so huge and unprecedented that one NGO wouldn't have achieved anything. Even joining forces with others, we were confronted in endless meetings by the power of industry that was objecting to increased rights for users, to increased enforcement provisions. Why? Because industry in particular, the big technology organizations are making a lot of money out of people's data, and increased provisions were not to their business advantage. It wasn't very glamorous. We're talking about hundreds of meetings with members of parliament, with representatives of governments, trying to convince industry to support us, wading through hundreds of articles in the legislation, drafting our own amendments. So it was a big slog. But what came to our advantage were two important allies. First of all, in the European Parliament, the so-called rapporteur for this legislation, i.e. the person that was coordinating all the political parties' input, was a fantastic member of Parliament, very knowledgeable, very on the side of civil rights. He's called Jan Albrecht, who's unfortunately leaving Parliament to become a minister in Germany, but it was great having him there and a great advantage. And also, don't forget the Snowden revelations back in 2013 that revealed all these mass surveillance practices by the US intelligence services and others in the UK and the so-called Five Eyes. And that has heightened the political feeling that something had to be done to protect people's data. So those two events were greatly to our advantage. Shall I talk a little bit about the overview of what the legislation does, and then you can go into detail? Okay. So I'll give you a brief overview of the new law. It essentially prescribes how companies, public authorities, and charities and NGOs too should process your personal information. Processing means not just collecting it, but everything they do with it. And it gives people who are called in legislation, they're called data subjects. It gives them a number of rights in order to control their information better. And also, it provides more ways to enforce the legislation and more obligations on companies. So it's just an increase in rights, it's an increase in obligations and more possibility for you to get redress if something goes wrong. It applies to commercial entities and public authorities, as I said. It doesn't apply to law enforcement entities such as judiciary or the police. They have a separate law, which is a directive, and that has to be enacted by
the legislation, which requires individuals to be given more clear, transparent information about what's happening with their data. And that doesn't, they're entitled to that even if it wasn't collected directly from that company, for example. So if they've had data about you provided by another company, you should still be being informed of that. So as well as this right to information, you also have the right to access, and this is your right to ask whether it's a company or a public authority to provide you with a copy of the data that they hold. And they're also required to provide you with answers to certain questions that you might have about that data. And you're entitled to response to that request within 30 days. It's free for you to ask for this information. And it's a really important right, so that you can check up and see how your data is being used. You've also got further rights, so you have the right to rectify. This is about correcting inaccurate data about yourself. You have the right to restriction, where you don't want your data to be used for a particular purpose anymore. You have the right to erasure. This is where you can ask for your data to be deleted in certain circumstances, although there are important exceptions to that, such as the right to freedom of expression. There's the right to object, and this right to object is absolute in cases of direct marketing. So if you are if you're the subject of direct marketing, you have an absolute right to object, and that has to be stopped. And there's a new right called the right to data portability under GDPR, and this right kind of builds on the right of access, but is different to it in the sense of it covers certain types of data, and it's your right to receive that data to yourself or have it transferred to another provider in a commonly used machine-readable format. This is basically making the data more accessible to you rather than kind of reams of photocopies, having it in a more kind of interoperable format to try and increase competition and give individuals more control. And there are also certain rights in relation to automated decision-making. That's where the automated decision-making is solely automated, and where it has an impact on individuals.
So a machine decides for you rather than a human being.
Yeah. So these are the rights that you have under GDPR as an individual, and it's to kind of give you increased control over your data.